Hello everybody and welcome to today's episode of Activist Lawyer Podcast. Today I am joined by Katie de Kauwe, who is senior lawyer with Friends of the Earth. And I'm going to go through the background here, an introduction for Katie, because some of the cases I mention here are really significant and we touch upon them in some more detail in today's episode. So Katie specialises in environmental judicial review and also has expertise in cases concerning the right to protest. Katie was listed in the ENDS Power List 2023 and 2024 of the UK's 100 most influential environmental professionals and was ranked in the Lawyer Hot 100 for 2023. Katie led Friends of the Earth's successful Climate Change Act challenges to the government's economy-wide decarbonisation plans, first the Net Zero strategy, and then the Carbon Budget Delivery Plan, which replaced it. She has worked on several critical challenges to fossil fuel projects, including Friends of the Earth's intervention in the landmark Finch appeal regarding oil drilling in Surrey, where the Supreme Court ruled in June 2024 that end-use emissions from fossil fuel projects must be included in the environmental impact assessment. Katie also worked on the organisation's successful challenge to the grant of planning permission for a coal mine in Whitehaven, which was strengthened by Finch and ultimately succeeded on all grounds in September 2024, including those aspects relating to substitution, international impacts and carbon offsetting. Katie leads on Friends of the Earth's casework on civil liberties, including its live application to the European Court of Human Rights challenging the use of anti-protest persons on known injunctions. Katie holds a degree in biology and converted to law through a master's in law. She previously worked in criminal defence and completed her training contract in private practice and worked in civil litigation before joining Friends of the Earth in 2018. She was previously involved in the Colombia Caravana and has participated in 2 human rights delegations to Colombia. Katie herself is half Sri Lankan and strongly believes in the importance of addressing the deficit in representation of people of colour in both the legal profession and the environmental movement. Now, all of the points that I mentioned there in Katie's bio and her introduction are really important, and we do cover them in detail, which I thought it was important to read them out beforehand. Some of the cases are truly fascinating and I would urge anybody to read these cases in detail. The links to the cases will be in our show notes and I hope you enjoy this episode as much as I did. So welcome to the podcast, Katie. Thank you for joining me on The Activist Lawyer today.
Thank you very much for having me. It's nice to meet you.
I'm really excited to get into the detail of your work that I've been following for the past while and some of the significant cases. I hope to discuss those in a little bit more detail. But just going back in time, I'm interested in your journey into law and, how you became involved with Friends of the Earth.
Well, I suppose my journey into law starts from quite a while ago because really my decision to go into environmental law and ultimately to start working at Friends of the Earth was motivated by my interest in the natural world from when I was a very young child. So I did biology as my undergraduate and then I converted to law. I decided I wanted to become a lawyer because whilst I could see that scientists were doing amazing work and research, it seemed that the international community was not really listening and hadn't been listening for a long time to the warnings that had been given over a period of decades about loss of biodiversity and the climate crisis. So I wanted to be in a position where I thought I could advocate for positive change. And I suppose also I could see that looking back through history, the law has been a very powerful means to contribute to taking society forwards, to making it better, and to improving the world around us. So I believe that, being a lawyer, it was possible to do that. And that was certainly a huge motivating factor for me. I think it's also the case that I was fortunate to have some very inspiring people in my immediate family. So I have an uncle who's a trade unionist for 30 years in the Department of Work and Pensions. So commitment to and belief in, the importance of social justice was, I suppose I was exposed to that from a very young age. And then also my father is a criminal defense barrister. And I think in terms of the, wanting more generally to become a lawyer and to have a career was something that I think I was also influenced by through my mother, who really emphasized, the importance of financial independence for women and women having their own careers, regardless of what their spouse or partner or whether they were single or not, whatever else might be going on. So I think those three people were a key influence, aside from my particular interest in the environment.
Excellent. And I know you're now a senior lawyer with Friends of the Earth. I'm wondering, can you share a little bit about the organisation with our listeners who might not be familiar with it, the mission and really what your role is now with the organisation?
Yes, so Friends of the Earth, England, Wales, Northern Ireland, which is the branch of Friends of the Earth that I am a part of, came into existence in 1971. So we are the largest grassroots campaigning organisation in the country, and we're part of a network, which is one of the oldest campaigning umbrella groups, I suppose, worldwide. We've got nearly 80 sister groups in the global south and the global north. And in terms of Friends of the Earth, England, Wales, and Northern Ireland, specifically, we are concerned with ensuring that we stand up for people and planet, that we push for a society that is socially and environmentally just, and where the environment is improved for everyone in it.
Brilliant. Well, I've looked at some of the casework that we might move on to discuss, and it's only when you get into the detail that you realise how significant the outcomes of a lot of the litigation that you and organisations like yours and litigants take on, because they really shape the landscape and the government's future policies around things like climate change, net zero and fossil fuels. So I'd like to maybe look at some of those cases if we can, Katie. One that really struck me was your challenge against the UK government's net zero strategy, which is really interesting and had an excellent outcome. And maybe you could discuss that a little bit.
Yes, of course. That was a very exciting case to be a part of. And I suppose in a way it was two cases, because Friends of the Earth, alongside Client Earth and Good Law Project, have twice challenged the government over their economy-wide decarbonisation plans. So the first challenge was against the net zero strategy, as you referred to, which was the strategy adopted to enable our carbon budgets to be met up to the sixth carbon budget. So for anyone not familiar with the term carbon budget, this concerns a target to reduce carbon emissions on the pathway to 2050, where we have a net zero target. And those targets are brought into law through the Climate Change Act 2008, which is a piece of legislation that Friends of the Earth campaigned for through the Big Ask campaign a couple of decades ago now. This first legal challenge against the net zero strategy succeeded on the basis of Section 13 and 14 of the Climate Change Act, which require the government to adopt policies that will enable the upcoming carbon budgets to be met, and also to put that in a report to Parliament. So that's the Section 14 duty. And we successfully argued that the government's net zero strategy was not up to scratch and was also unlawful, because they had not, one of the key aspects was that they had not actually quantified what the emission savings were for the individual policies, and they hadn't included that information in the report to Parliament either. So the upshot of it was that Parliament was not aware that there was around a 5% deficit in terms of what the policies were expected to achieve in terms of meeting those carbon budgets, in terms of the quantified policies, the working which had not been included in the report. So, and in terms of that deficit, we were talking around 75 million tons of carbon dioxide, so not an insignificant amount by any means.
Absolutely.
A rather gaping hole.
Yeah.
So yes, the High Court found our combined legal challenges successful. So the government was ordered back in July 2022, rather curiously on the day of the record temperature wave in London, where it was 40 degrees Celsius.
Right, yes.
I'm sure everyone remembers that, those conditions. But they were ordered to produce a revised plan to correct these legal errors. And I think that case, and also the case that followed with the carbon budget delivery plan, which was a sort of successor to the net zero strategy, and succeeded again on a similar basis, this time in terms of the level of risk associated with the plan and what the Secretary of State who adopted the plan actually knew about it. Both of them have really shown that the Climate Change Act is an act which has teeth and which can be enforced through the courts if the government does not comply with it or does not take its duties seriously enough. This is not some sort of, wishy-washy piece of legislation that doesn't need to be engaged with. And it also shows that there are groups in civil society who are willing to hold the government of the day accountable if they fail in their duties, because ultimately having a plan which has ambition and that has the foundational basis to deliver the emissions cuts that are required under law is absolutely essential if we are going to address the climate crisis properly. So, yes, I think it's we obviously have a new government now in office, Labour government. So this requirement to produce a revised plan has now fallen onto them, and that is due to be published in May of next year. So Friends of the Earth, and I'm sure others, will scrutinise that plan very carefully when it comes out. And we, of course, our campaigners are working on trying to advocate for a plan which is both fair and ambitious, so that the transition to a decarbonised economy is a just one, and where existing inequalities aren't exacerbated by the transition.
Yeah. And I mean, what really strikes me by, the outcome of these cases, as you said, it's really about holding the government's feet to the fire. That's part of it, but also improving the lives of communities and striving for better, greener jobs and sustainable communities. But it really is getting the message across loud and clear that the Climate Change Act, it's not optional. And I know that very often it will depend on whatever government is in place at the time. So I hope that the strategic litigation alongside the campaigning will really make for a positive outcome with those plans. But I mean, you're to be highly commended, you and everybody who took those cases around getting that message across loud and clear. I think it's really important. Another case that I also had the privilege of talking to one of the KCs who was involved in it, Mark Willers. He was on our podcast the day the judgment came through. And the case is known in various different titles, I think, Finch and Horse Hill case. And I know that you were heavily involved in that and your organisations as well, along with the grassroots campaigners. And I wonder if you could go into a little bit of detail with that. We had the outcome that day, but we didn't really get a chance to discuss it in great detail. And I'd like to know also the significance that case will have on similar cases that are going ahead in the UK, but also outside the UK.
Yes, certainly. First of all, I think it has to be acknowledged that the real heroes of that case are Sarah Finch and the Wheeled Action Group, because they were the main party, the claimant, and later the appellant, who brought that case. Friends of the Earth was very proud to be involved in a supporting act way. We were contacted by the Wheeled Action Group back in 2020, before the hearing at the High Court, to ask if we would intervene to support their legal challenge. And that's what we did. We were granted permission to intervene in the High Court, then in the Court of Appeal, and then in the Supreme Court, when we were also joined by some other interveners as well. So, yes, that case, it was a real privilege to be involved in it. And I think one of the issues that stood out for me amongst the very importance of the case in legal terms, and perhaps something that we'll come on to a bit later, was that this was a case brought by a woman on behalf of a group largely comprised of women, and also, as well as the brilliant Mark Willers, his co-lead counsel was Estelle DeHaan KC, who's an incredibly trailblazing environmental barrister. And I think when you look at this in the round, the legal profession, the environmental movement are not representative as yet of society as a whole. They are very white middle class dominated, and particularly white male middle class dominated. As you go up the legal profession, there's a seniority gap that still remains, as I'm sure you're very aware. And so being part of this case, which was so important with all of this female leadership, was really exciting. And it just reminded me also of so many other cases and campaigns relating to the climate crisis, which are led by women in other areas as well. So, for example, the Nanas, who were a formidable group who fought the fracking industry when before the fracking ban was introduced. They were known for their yellow headbands. They were mainly grandmothers and older women, some of them retired, some of them who hadn't been involved in campaigning, but they maintained a vigil outside Quadrilla's fracking site in Lancashire for a period of years each morning. And then also other members of the Wheeled Action Group had also fought a anti-protest injunction taken out against persons unknown, so very broad-ranging injunction taken out by UKOG, UK Oil and Gas, the parent company of the developer in the Horse Hill Sarah Finch case. So I could see it in terms of the round and just how important and what a prominent role women across the country are having in standing up for future generations and forcing accountability on the climate crisis. So it's very exciting from that sort of gender justice perspective as well. In terms of the legal work and the significance of the case, as I'm sure Mark will have said, it's quite hard to overstate how significant this case is. There is a reason, of course, that Sarah Finch and the World Action Group decided to take it. There is a reason that Friends of the Earth chose to get involved with it. For us, it was that, we believe in the power of grassroots community action. So we wanted to support this group. Also, we could see the strategic significance of the case, because this was all about responsibility for the full climate impacts of fossil fuel developments. Yeah. And developers have been arguing time and time again that the emissions from actually using the product that they extract from the ground, its end use, are not their concern. They're too far removed. They're, occurring elsewhere. There are too many intervening steps. Blah, blah, blah. It's the same thing over and over again, like a broken record. Yeah. And this case, having lost in the High Court, having lost in the Court of Appeal, the Supreme Court ruled by a 3-2 majority, with Lord Leggett giving the majority judgment that no, these end-use emissions from burning the oil, which is where the vast majority of emissions, oddly enough, arise, are effects of the development. They are indirect effects. They are inevitable emissions. It's artificial to try to distinguish consequences from effects. And therefore, that it was unlawful of Surrey County Council to not consider these emissions when they were granting planning permission for this development. Just to give you a sense of the scale here, I mean, the Horse Hill oil site, comparatively small site compared to some other fossil fuel projects, but the importance of it is, as well as for the site itself, is that this has the same rules apply for much larger fossil fuel projects too. But with Horse Hill, it was estimated by the developer that the emissions from literally digging the oil up out of the ground were around, I think, just over 100,000 tons of carbon dioxide equivalent. But for the emissions from burning the oil, that was estimated at over 10 million tons. So it's really a tiny proportion that had been factored in by the decision maker. Yeah. Then if you look at the Whitehaven coal mine, which was also successful in part on the back of the incredible result in the Supreme Court, the scope 1 and 2 emissions there were around 2 million tons, so already very large. But the end use emissions from burning that coal would have amounted to over 2 million tons. So hugely, hugely significant. And there is a reason that developers have been trying so hard to keep these emissions out of the equation. And that is that they must have realized that if decision makers were confronted with the true reality of these climate wrecking projects in terms of their carbon emissions, they might think twice before granting them planning permission. Yes. And that to me is why it is, that to me is the obvious reason for why West Cumbria Mining Limited, the promoter of the Whitehaven coal mine, chose to involve themselves as an intervener in the Supreme Court in Sarah Finch's challenge over the Horse Hill site, which on the face of it had nothing to do with it. It was in the opposite end of the country. It concerned oil, not gas. Sorry, oil, not coal. So there we are. And just I suppose one final thing, it's not just Whitehaven which has been impacted by this case. There have been a whole host of other oil and gas projects which have been affected too, including a project in Biscathorpe. And I think the entire sector is waiting with bated breath to hear what the result of the Court of Session decision will be in relation to the Rosebank oil challenge brought by Uplift and Greenpeace. So a clear example of when Friends of the Earth has been very obviously affected by one of these injunctions was when Quadrilla took out an anti-protest injunction against persons unknown over its Preston New Road site. And it was actually broader than that as well. And we had been working for some time with the Nanas and other local community groups in protests and various other ways to bring attention to the fact that the local community did not want fracking at this site. But with this injunction being brought in, then we were suddenly in a position of not knowing whether we could continue with those activities or the extent to which that we could continue with them, because the injunction was drafted in such a wide-ranging way. The penalties for breach were so severe. So overall, we saw, and this affected us as well, a real chilling effect on lawful and peaceful protests because people were simply scared about what this injunction was and how it could impact on them. And that is one of the examples that we refer to in our case before the European Court of Human Rights.
And that's an interesting example, but broadly speaking, the fear is, that it would be, as you mentioned, almost like a deterrent. Which is why, this case is crucial. These cases are crucial to bring, and that's a really good example of how that works. So, Katie, as well, you mentioned briefly there persons unknown injunctions and these anti-protest injunctions, which relate to a ban on activities. I read a little bit about it over the last few days, and it's quite worrying, to be honest. So I know that your organisation and your team have taken some action around these.
Yes, so it's a case taken at the European Court of Human Rights, and it concerns what we believe are measures that interfere unjustifiably with really important rights under the European Convention of Human Rights. So it's Articles 10 and 11, which, as you know, concern freedom of expression, and also Article 6, the right to a fair trial. Basically, for a number of years, Friends of the Earth has been very concerned at an increasing use of civil orders to substitute, it seems, for the criminal law when it comes to public order issues. They are being taken out on a very widespread basis by public authorities and by private companies in order, we would say, to create their own bespoke public order laws for their sites or their properties or places where they're operating. And we believe that this is very, very concerning for a number of reasons, including the fact that it is effectively a bypassing of the criminal justice system, which has, for all its faults, and I'm not going to pretend that our criminal justice system is perfect or that there aren't severe problems with it, because obviously there are. But, for example, there is a public interest test that the Criminal Prosecution Service must apply before deciding to charge somebody. There's no such public interest test when it comes to a company deciding whether or not to bring enforcement proceedings for breach of a civil injunction. There's a lack of independence as well, because the party that obtains the injunction is the same party that chooses to enforce it. Again, the complainant in a criminal law setting does not make the decision about whether to actually bring a prosecution. That is an independent body, the CPS. And there are other issues as well, like there are no juries in civil law proceedings. So for an equivalent, behavior or conduct, which might result in a criminal charge, and then someone goes before a jury and is judged by their peers. With this, the person will just end up before a civil law judge. There's also a very serious issue with cost and adverse costs, because under in the criminal law, it is basically very rare to get hit with any sort of significant cost penalty beyond, a fine, if that is the penalty for which the judge decides to elect in terms of the sentencing. But with injunction proceedings, you can be enforcement proceedings for an injunction. You can face an unlimited fine. You can go to prison for up to 2 years. You can face asset seizure. And then you can also have to pay the adverse costs of the other party, so the private company or the public authority who's brought the proceedings against you. And those can run to tens of thousands of pounds, because there's a complete lack of clarity on whether there's any cost protection available. None of that happens in the criminal law in terms of the adverse costs issue. So I've given a sort of broad sort of background in terms of the practicalities of these things. In terms of how they are affecting Friends of the Earth and other organisations, I think there was a report in the BBC in summer of this year found that there were 12,000 sites across the country where slow walking, which is a very traditional long-term peaceful protest tactic, is banned. Across 1,200 sites across the country. There are orders in place from companies like Shell in relation to their petrol stations, for example, which make it nigh on impossible to form any sort of protest around those sites, and those are sites all across the country. Injunctions were taken out by HS2, and they've also been taken out in relation to sites concerning environmental waste, where there have been concerns by local communities about the health impacts of those waste sites. So They are a very they're very dangerous because of all the sanctions that are possible, and the wide-ranging terms that are included in them.
Incredible.
And also the fact that they are often obtained on a without notice basis, so that generally speaking, you will often just have the party seeking the injunction in court at the time, and then there's nobody else opposing them. Yeah. But then if you want to try to vary or challenge that injunction, or oppose it for that matter, you are again putting yourself at risk of significant adverse costs, because again, there's this lack of cost protection.
It's incredible, yeah.
So for all these reasons, Friends of the Earth was involved in several challenges to these injunctions, including those taken out by INEOS, by UK Oil and Gas, and more recently in the Supreme Court, a load of local authorities had taken out injunctions, persons unknown injunctions taken out against basically the whole world, just defining defendants according to prohibited conduct. And that concerned gypsy and travellers, actually, but we intervened on the protest angle there. And yes, that judgment came out at the end of last year, and it was not helpful in the protest context. It's basically left the door pretty wide open. So we feel that we've exhausted all domestic remedies, and hence are taking this challenge to the European Court of Human Rights. I should also mention that the Wolverhampton judgment makes clear that this power to grant injunctions against persons unknown is a judge-made power rather than one that is grounded in statute. Yeah. And so we feel that it is probably most useful to challenge this through the European Court of Human Rights as a result.
I mean, it's really worrying. People should be concerned. And it's a chilling effect on democracy at large. So in terms of civil liberties, taking this case is pretty seismic, and the outcome will be pretty impactful on so many people, individuals and organisations. So yes, it's definitely one to watch. Stepping away a little bit from your workload, I note with a lot of your cases and with Friends of the Earth, a lot of you collaborate with many organisations. And how important is that in terms of not only getting results through strategic litigation or the legal actions that you take, but in terms of holding the government account, that level of collaboration, how does that influence the outcome?
Well, I think first and foremost, given our purpose, we want to, as much as we can, work alongside and support directly affected communities, to support grassroots initiatives. So that is why with the Sarah Finch Challenge, as I said, we wanted to intervene to support that community group. With our challenge against the Whitehaven coal mine, we did that in conjunction with another community group, South Lakes Action on Climate Change. It's very important for us that as much as possible our cases are linked to local action, so that we are supporting the voices of local people. And also, as I said, honouring that commitment to grassroots work. So I think that is particularly important in cases like that. I think it is also very important where possible to work alongside organizational sector allies as well. So, for example, in the, I haven't mentioned this before, but in the intervention that Friends of the Earth made in what is known as the Frack-Free 3 appeal, which concerned 3 peaceful anti-fracking protesters who'd been locked up for 15 and 16 months for peaceful protest. We intervened in that sentencing appeal alongside Liberty, bearing in mind the different perspectives that we could bring. One of us a purely civil liberties organization, the other an environmental justice organization. And we collaborated with them and coordinated on our submissions. And yes, that sentencing appeal was successful, and those people walked free that day. That was back in 2018. So that was an amazing case to have been a part of. Yeah. And then, of course, more recently with our legal challenges against the government's decarbonisation plans, coordination with other organisations who were concerned about those plans was very important as well, to both to, benefit from the knowledge that each of us had, but also to ensure that we were aligned in terms of the arguments we were bringing and not undercutting each other. So we brought separate challenges, but we coordinated on that throughout as well. I think it is also important, given there are, at any one time, it is the reality that there are a lot of bad environmental decisions being made. So I think it is also very important for the sector to be talking to each other, so that people can be covering different things as well, rather than having everybody focus in on one thing, because otherwise other really important issues aren't being addressed. So I think there is a balancing act between coordination and working together on cases, and then also respecting the space of others, and vice versa, so that there's a good spread of, the sector generally trying to answer and help with the problems that are occurring all over the place.
Interesting. Yeah, so it's a coordinated push, I suppose, and kind of shared learning as well. Just one question that sprung to mind there in terms of when you've the community is at the centre, of course, of any decision that you make in terms of taking on cases, and you've just mentioned about how you coordinate with other groups as well. But when you're up against such big corporations or the local authority, for example, very often their argument will be, well, look, we're creating jobs for the region. And I'm wondering how, in reality, after you have been successful, let's say, in your litigation, how you ensure, and organisations that work alongside you, to make sure that the government are, maintaining their commitment to the creation of greener jobs or more sustainable ways of life for those communities, so they're not just left without, for example, what they might see as, a lack of jobs or unemployment that potentially arises from, as a result of the litigation. It's just a thought.
Yes, I think it's a really important point that you raise. This, for me, is one of the reasons why it's so brilliant to work at an organisation like Friends of the Earth, because we are not just a legal team. In fact, our legal team is pretty small in terms of the organisation as a whole. Our legal work is very much a part of and seeks to help achieve the objectives of our campaigns. And so when we work on cases, as much as possible, we try to integrate them into wider campaigns. So in terms of the decarbonisation plan challenges, we have, with the carbon budget delivery plan and this, revised plan that is being as expected to be produced in May, we have a whole host of campaigners who are working on lobbying the government and advocating for the need for a new plan, which is just that does provide, for investment in green energies and providing for green jobs, etc. So it's not just a case of, us taking a legal challenge and then that's it, and expecting that to actually change things in and of itself, because it can do that sometimes to some degree, but you need to have the then push in terms of the changing of political minds, or the policy push, to ensure that the opportunity that a legal win creates is actually taken advantage of. And so with another good example of this is our Whitehaven legal challenge. Again, our Whitehaven campaign was very much broader than just the legal challenge. We had links, we had colleagues working with community groups who were very concerned about the mine in their area, a whole range of groups. We also were working very hard and continue to work hard to, beat the drum for the need for green jobs in these areas, because it is, it's a reality that places like West Cumbria have been severely underinvested in and let down by a whole succession of governments. Unemployment is clearly a major issue. Our position is that what the area needs and deserves is long-term, good quality jobs that have a future, rather than dead-end jobs that are going nowhere. So, one of the things that we have been pushing for example, is, why not invest in offshore wind? West Cumbria is an area of the country which has huge potential for that, and that would create far more jobs and jobs for the longer term than the coal mine, which, was talking about aiming for 80% of the jobs offered to go to local people, but that wasn't guaranteed. And in any case, there is no future in coal. There's no future,
yes. I find that so fascinating that it had a very short lifespan in terms of they were intending that coal to go towards steel manufacturing, I think. That wasn't going to be around for very long anyway. So, yeah. That's great to hear. I'm glad to hear the detail around that. It's just something that crossed my mind. We touched on some of your very important work. I'm sure there's a lot more, but I'm keen to know, are there any particular cases or campaigns that you're particularly proud of? I know you're probably proud of a lot of that work and a lot of the success there, but is there any one or two cases that stand out for you that you're really proud of as an organisation or on a personal level?
I think for me, the two cases that really stand out, and there have been lots of cases, lots of advisory work relating to campaigns that I've really enjoyed and been very proud of. But I suppose the two absolute highlights are the Horse Hill Finch judgment, and then the Fact-Free 3 sentencing appeal that I mentioned before. The sentencing appeal was back in 2018, so it was quite soon after I joined Friends of the Earth. But I think it was an incredible case to get involved with, and it was, I think, a part of the reason it resonated so much with me was going into the court and seeing an absolutely packed courtroom with lots and lots of people with the red rose of Lancashire, which had become this anti-fracking symbol, and they were all just lined up in the public gallery, sitting and watching, and then getting the judgment and seeing the immediate impact that it had in terms of those 3 people walking free that day, bearing in mind the level of resistance there was to fracking in the Lancashire community and how it had been forced on them by the Westminster government, because the local council had actually rejected planning permission for the fracking site. It had only been brought into effect because that had been overruled by central government. So local communities' wishes had been ignored and trampled on, and that was the sort of context for the protest that had happened. So it really felt like justice had been done that day. And then the other case, as I talked about at some length, but the Horse Hill challenge, for a whole host of reasons, including those I've already mentioned. I think just the level of persistence and determination that the Wheeled Action Group showed in being willing to pursue that case all the way to the highest court in the country, having had so many setbacks. Rather extraordinarily, it was refused permission on the papers. It was the original High Court judge who looked at it thought it was entirely unarguable. It was refused again at a renewal hearing. It only got to go ahead at all because they went up to the Court of Appeal, who granted permission, and then it went back down to the High Court. So, yes, just the level of determination that they showed, the privilege for me in being involved in that case. And again, the immediacy of the impact, the domino effect that it has had, the fact that it has fundamentally changed the landscape for fossil fuels getting permission and made it that much harder. I think, as you said yourself earlier, it is a real blow to the fossil fuel industry, both in this country and internationally, given the common basis for environmental impact assessment, certainly across Europe. Yeah. But also it's a further blow, beyond that, because practically every country in the world has got some sort of environmental impact assessment regime, and they all stem from, a similar basis. So it's incredibly exciting. Obviously, for instance, the Earth's position is that there must be no new fossil fuel projects. They're not compatible with the 1.5 degree target under the Paris Agreement. The Committee on Climate Change has said that new fossil fuel projects are not compatible with a net zero pathway either. So it's a real help or stepping stone towards that wider goal. And it was such a privilege to be part of a case that has changed things for the better in such a clear way.
Yeah, truly, it's extraordinary. And just to even hear about the determination of, the grassroots activists and the campaigners who are persistent. And it's not an easy feat or a task to undertake to go through the highest courts in the country. So very, very exciting. Just zooming out a little bit, I'd like to just get your opinion on something that I've been reading up a little bit about in the broader context around climate justice. And it's the connection between gender inequality that we're seeing a little bit more in terms of research coming out in that and climate change. What are you or your organisation looking at in terms of that?
Well, I think, it's been known for some time, hasn't it, that climate impacts are not evenly felt across society or across the world, and that those who have contributed the least to the climate crisis are the very people who are suffering and will suffer the most from it. So gender is definitely a key dimension of that injustice, along with other factors like racial and also disability justice issues. So it's very clear from reports from the UN going back many years now that women are disproportionately impacted by the climate crisis, particularly women in the global south who are engaged in farming and collection of food for their families, and how that's being how crops and vegetation are being affected, and how that's impacting on their ability to feed their families and themselves. For example, I suppose Friends of the Earth, England, Wales and Northern Ireland, we are every campaign and every case that we take, we look at it to see how we can maximize issues around justice in all the components of it. So, gender justice, racial justice, disability justice. It was a factor for us in getting involved in the Horse Hill Challenge that this was a group comprised largely of women, and certainly when we worked with the nanas in their fight against the fracking industry, which we supported through our fracking campaign, we highlighted that this was, women leading this fight again. So I think that's the way that I try to approach it in my work, and in terms of like how we find examples, how we find the best examples to both ensure that we have strategic impact, but that ensures that we're pushing that wider narrative that isn't always that well understood, or that has been underappreciated, particularly in the context of an environmental movement that, as I said at the very beginning, I think of this podcast, has this legacy and continues to be dominated by white middle-class men in terms of those who are in positions of power within it, generally speaking.
Sure. And another, a global movement that we're seeing is a surge in cases taken by young people and young activists getting involved in litigation. And I'm wondering, how does your organisation support that, and maybe how the legal system can better support their activism? Because at the end of the day, they're going to be largely impacted by a lot of these changes that we hope to see in place. How do you see that progressing?
Well, I think in terms of Friends of the Earth's work, in several ways. So first of all, we have a My World, My Home team who work specifically with young people in college, provide training and guidance on how to campaign effectively on issues in their local community. We try to integrate their work into our campaigns in various ways. So in our legal challenge against the government's plan to adapt to climate change, the National Adaptation Plan Challenge, which unfortunately did not succeed in the High Court, but we are considering an appeal. The members of our My World, My Home network came to the court, were part of the demonstration, had the experience of seeing, a hearing in action. And then I suppose in terms of the work that I'm directly involved in terms of the protest rights work, protest rights are something which matters for everyone across society, but it is, I think, clearly the case that there are a lot of young people who are very frustrated by the lack of progress by our government and governments across the world. And so being able to engage in protests for them is very important. And so I see that as part of our contribution to safeguarding the rights of younger generations. Of course, there are people of all ages who take part in protests, but there is, a very clear contribution from younger generations. And then I also think in terms of young people and, the future of environmental law, Friends of the Earth England, Wales and Northern Ireland has I think it's pretty much a unique legal internship scheme, which is funded at above the London living wage. It's a 12-month internship for people at the very start of their careers who are aspiring environmental lawyers. And with that, we have the great privilege of working with very talented, very committed young lawyers who contribute enormously to our cases in a whole host of ways. There were several people, for example, who worked with me on the intervention in the Horse Hill case. So Millie Jean-Pierre, Vivian Ayadogbon, and Alex Mousset in particular. They're all former legal interns at Friends of the Earth, and they contributed at the different stages of the intervention across the tiers of the court system. And being able to offer that opportunity is, we hope, a contribution in the long term to the environmental movement, and a movement which is better representative, more representative of society as a whole.
Yeah. The next question that I ask really feeds into a lot of that, and it's really the thread of our discussion today. I suppose it's quite an obvious one, but I'm wondering around your view of activism, the role of activists and activism, and the law in terms of driving meaningful change. That's your work, I guess, as opposed to a lot of our guests who come on. But I'm wondering how you view that and how important it is to have, yes, the strategic litigation in terms of outcomes, but the campaign element to run alongside that.
Yes, sure. I went into law because I wanted to fight for positive change in the world. I wanted to be a part of that. I wanted to be able to go to work and to feel like my work was aligned with my values, that I was contributing to something bigger than myself. And so for me, I suppose you can call it, or one can call it activism. but that is the fundamental reason that I am a lawyer. I never would have wanted to be a lawyer who was in an area that was really only serving their clients in a very narrow way and that wasn't contributing positively to wider society, was possibly even doing the opposite. I know I would have been very unhappy in a career like that. I think sometimes there can be an idea that lawyers who are pushing for positive change are somehow doing something a bit different to what other lawyers are doing. But I think there is an element here of, most things that we do are political to some degree. And it may be that if you're acting for, an oil company, for example, then you are making a contribution politically, but it may be to the status quo rather than to, a movement that's trying to change things for the better. So I think the idea of that you're only sort of engaged in any sort of political ideas if you're pushing for positive change is sort of ignoring the reality of there's a politics to maintaining things as they are. And just to add as well, I think there's a very long history in this country in terms of lawyers or people with an interest in law trying to use the law to advance justice issues. So, for example, before the slave trade and before slavery was abolished in this country, there were lawyers who acted for enslaved people to try to prevent them from being deported or taken against their will from this country back to the plantations in the Caribbean. Granville Sharp is an example of this. And they were really ahead of their time and going up against the legal system, which was confronted with the reality of how on earth do we justify slavery in legal terms when England is so proud of the idea of the freedom of the individual. So, yes, those cases sometimes succeeded and sometimes didn't. But it's an example of lawyers acting, fighting for a cause that really was just and trying their very best to use their skills to assist their fellow, human beings who are being subjected to the most awful barbarity, as everyone will appreciate.
Absolutely.
And that's just my perspective, though.
It makes sense. I mean, given your role and the organisation that you're working with, and I think many people will be interested. I mean, it's an emerging area of the law in general, so to speak, in terms of the precedents that are now being set by judgments that are coming out that are really important and really impactful, and not only on the law going forward, but how policies are created. So I think it's a really, a developing an area of law that's developing quite quickly, but you look at it with a global perspective as well and how much it's interconnected. So I think it's a prime example of how activism, if we want to call it that, but how campaigners and, the law strategically will work to make that change that's needed. Just in terms of people who are listening, and Katie, our final question, who are interested, and I'm sure there's many, in pursuing a career like yours in environmental law and climate justice, what advice would you have for them?
Well, I think it's great if you want to pursue a career like this. I think depending on what stage you exactly are, but say you're at university, I would say make the best use you can of the opportunities for involvement in student societies, legal clinics, things that will demonstrate your commitment to social and environmental justice. Because I think working for an organisation like Friends of the Earth and getting a role in an organisation like Friends of the Earth, you need to show that you are a lot more than just a bright lawyer who understands and understands law and is intellectually, gifted. You need to show that you are committed to the cause. So building up that experience is a very good idea from early on. I would say try to get some foundational experience once you leave university as well. So there are opportunities at places like the Environmental Law Foundation, at RSPB, I think, as well. And as I mentioned earlier, Friends of the Earth does offer a legal internship scheme. We recruit every 6 months. So I think our next round of recruitment will be in around February, January, February. And be persistent, keep believing in yourself. Don't be discouraged if you don't succeed at first. I left university in 2012, and it wasn't till 2018 that I started working at Friends of the Earth. So there was a period of time before I broke into the area that I really wanted to. If you are really sure that you want to do environmental law as opposed to another sort of public interest area, don't be put off, and be willing to take opportunities in, I suppose, other public interest areas, because a lot of the legal knowledge that you will acquire will be transferable to environmental issues in terms of understanding of court process and things like that. So I think those would be I think that was 4 key tips.
Excellent tips. Well, Katie de Kauwe, senior lawyer with Friends of the Earth, thank you so much for sharing your work and your journey into this fascinating area of law. I wish you all the best, and we will watch with keen interest on the developments of future cases.
Thank you.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.